Okay. Uh, we'll open up the subcommittee. And it's funny, I get into this committee room and I always take my jacket off. And this is the first time I've actually been cold. Okay. 164, relative to homeowners prohibiting certain types of service agreements. All right. So who's here to worry about this issue? Okay. And you are again? Your AARP. Okay. Okay. All right. I've really been struggling over this bill. My memory, there was something in here about 1 to 2 years. Do I not have the right pile? Why don't you take a seat over here?
Page
So you have
114.
Okay. Yeah.
Yeah.
So the one. Yeah, so to the 2 years, exterminate agreement unfair under this is not to be formed within 2 years after the agreement is entered into law or any of the following characteristics. So theoretically, if we just say that any lien of this sort is has to have been satisfied within 2 years.
So I do have a few documents to circulate, if that's okay. Do you mind if I just circulate that for the committee
Sure.
for reference? Actually, thank you.
This one.
There's two separate ones.
Getting on that thing, too.
That was the process of unwinding it.
Yeah.
So, and just for the record, my name's Mike Padmore. I'm the Director of Advocacy with AARP New Hampshire. It's great to see you all again. So I've passed around a couple different documents here. There's two. One is a mock-up. It's an informal mock-up of the legislation that covers a few different changes that I suggested based off some of the feedback that we've gotten from some of the different parties and some of the feedback that we've gotten from committee members. I'll note that the first section, when we're talking about service agreement and striking the word maintenance, I do have an additional change that I don't have in that document that I'll walk through in a second. But a few of those changes were things that we suggested, talking about making it very clear that these agreements are unenforceable. So that's in the section when you go down a little bit further. That's in section Roman 5. And then the other change that you'll see in there that we talked about last time was striking Roman 6C, and that was from the Registrar of Deeds, Kathy Berube, who testified, ensuring that we strike that. I actually did have a conversation with Kathy, and Kate Horgan, who represents the counties, is behind her if she wants to speak any further. But I spoke with Kathy, who she did have one additional change that she wanted to make, which we are completely fine with. And that is just strengthening when you look at this is Roman 6A and 6B, adding to the end of that. This does not apply to anyone working in their capacity at the Registry of Deeds office. And what that does, and again, Kate can speak to this further, but what that does is just make it very clear that the registrars are not liable if they record one of these agreements, because they are bound by statute to record, an agreement that comes to them. And so we do want to make sure that that's very clear, that they are not the ones that are liable under that. So just going back up, though, I remember from the discussion that we had at the hearing, and Chairman Hunt, I think one of the questions that you had was around the term service agreement, that might be a little bit broad. And so in talking with some different subcommittee members and talking with the Realtors Association and the Registrar of Deeds Association, what we came up with was, which we feel like is a little bit more clear, is instead of calling these service agreements, calling them future right to listing agreements. So it's just very clear, this is about a future right to listing. That's really what we are concerned about. And so if we're changing that definition, what we would suggest it change to is when we're talking about Roman 1A, future right to listing agreement means a contract under which a person agrees to provide future right to listing services in relation to any residential real estate, period. We think that covers this pretty clear. And this is really what a few of the other states, if you look at one of the other documents that I sent around, that's what Maine just passed. And this language, it effectively says, they use some different words, but it is effectively the same bill. And it is very focused on residential real estate. And that's what a lot of the different states, again, there's 30 that have passed this around the country. We feel this makes it pretty clear that what this is about and is very similar to what other states have done.
But it's still under the Consumer Protection Act.
So the enforcement mechanism would be under that. And that's because any sort of a deceptive practice, and since we're considering this an unfair service agreement, that would be this would fall underneath that. And so that's where that enforcement mechanism comes in.
Bob, I can't see you. I got a speaker in front of me. You mind just come over here and take a seat in front of a microphone? So we're narrowing down to that. This is a very unique when it comes to leaning, right? Even though we have our bank commissioner here, then when it comes to liens, which when real estate normally is a financing issue, and in this case it might have been a finance because we're assuming this person is who securing one of these liens is paying the owner something of the property to get this lien. If we're trying to narrow it down, we're trying to get this and without cluttering our statutes with some obscure situation. And let alone even if the lien got recorded, you still have to I guess some process to get rid of. But we have another bill that we did where we made it so that if the lien had 5 years and it was made to disappear. So which seems that somehow I feel it's like these are all somewhat intertwined in terms of how we're going to the same idea of how that. If you say a lien, if we were to simply say is that if someone was going to record one of these liens, you have to do it. It would expire in 2 years. Let's say it had a limit to how long it exists. Okay. Let alone, I guess the next question is whether it's appropriate that someone does this at all. I mean, so yeah, Representative Spear.
I looked at it a lot, and and I keep coming up with the idea. I can't figure out why, like you said, that it should be done at all. That any service contract that puts a lien on a house, that you don't do it to your car, you don't do it to anything. A service contract that you don't pay for just dies, and you might have to pay a penalty. I mean, some people do have to pay penalties, but they don't take your house, and they certainly don't take your car. So I'm not
The car
clear.
would be a UCC, and that is recorded. And so yes, they can take the car back.
No,
If
the
they-
loan, they can take the loan because the loan, you were given money in exchange for a car. But if you have your extended service warranty, they don't take the car if you don't pay it. They just cancel the policy.
Right.
This is not giving you a loan to pay for your house. It's giving you a service contract.
Well, again, and it's not even a service. I just hate that term, service.
Oh, okay, it's really
A
what is it,
lien.
a
This-
selling agreement?
It's what it was a future right to list.
A listing agreement.
A
They're
listing,
giving you a
future
listing
right.
agreement. And
Yeah.
you never pay for that. I mean, they don't take your house if you don't pay for it. But I think that they're using that to hide something else that's going on here. Because they give you money up front and they take money away from you if you don't do it.
Yeah, but it doesn't even tell you how much money they're going to take away. That's
Well,
the,
I
that's
don't
the
know, yeah.
obscurity of this whole item. Because normally, when you have a lien, which is you're getting financing, bank finance, you know exactly what the terms of the lien is. You know your terms of what you
Right.
got to
In
do
this
to
case, you
satisfy.
don't
it.
know.
You don't even know anything. They're just will.
So just make it you can't have a service contract that puts a lien on a house.
So the simplest thing is, can we just make this activity illegal? Period.
Yeah. I
But
think you should.
evidently we can't, because that's why we have a 2-page bill. Bob, is there a way we can fix this quickly, easier than? I mean,
So I think you're, Bob Quinn, I'm the CEO of the New Hampshire Association of Realtors. I think that you have identified the two issues appropriately that you, in Maine and in other states, 30 other states, they kind of do two different things. They make the actual agreement illegal, the signing of the agreement, and then they also make it prohibit you from putting a lien on someone's property with this agreement. So there are two parts of the bill. And I think SB 164 does that. I think if you look at the Maine law, which has been distributed, and there are others, Colorado has done something recently very similar. So it's really that the two pieces that prohibit the ability of someone to enter into the agreement, but also prohibits you from putting a lien on someone's property.
right. Now, are you familiar with this Maine statute? Have you?
Somewhat, yep. I mean, it's new. I think it's a year or two old.
How do you feel about that language?
I think both the Maine language and the language in SB 164 do the exact same thing. As Mike and I have talked, the Maine bill, it does it with fewer words. Whether or not
Which
it's a
I
good-
like.
which is a good thing or bad thing.
For me.
But they're both getting to the same place, which is prohibiting someone from entering into these agreements, and then prohibiting someone from putting a lien on property with one of these agreements.
And I think it's important not to have a time limit. That 2-year thing, no, they shouldn't be in it at all.
Does Maine have? Maine has the 2 years also. Any portion of under this,
I think you're
if you put in more than 2 years after the date of contract becomes effective.
May I jump in with just to address that?
Yeah.
So I think the time limit is important, and I think one of the things that Mr. Quinn and I have discussed is that what we don't want is we don't want to prohibit legitimate listing agreements that realtors have with homeowners, and so part of why having it have in this case 2 years is that this is talking about again that future right to listing, and so that's why we're thinking that changing that service agreement is good in the sense that it is really talking about these agreements, which the agreements we're talking about are written so that these are 40-year listing agreements, and that's really what we want to protect homeowners from.
Does a real estate listing agreement ever put a lien on a house?
I don't know if I can answer that. Yeah.
I think that Representative Thaxton said absolutely not. They don't. And
That's my
therefore,
understanding.
There's no need for the 2 years because it's not legal to begin with. A legitimate listing would not put a lien on a house. So if it's an illegitimate listing, then get rid of it. Don't do it.
Right. Well, so the way that we have it written is effectively we're talking about the time limit of 2 years. So the services have to be provided within 2 years because I think we're finding that it's most common that a listing agreement would be no longer than 365 days.
But a listing agreement doesn't put a lien on a house. So I don't know why that even is considered as
So
part
Well,
of this.
let Bob answer this question. Yeah.
So I think there were two, again, going back that there were two parts to the bill. So on page 1, line 14, it
Which
says,
bill are you looking at?
164.
Yeah. So on 164, on
164. So it says a service agreement is unfair under this section if any part of the service subject to the agreement is not performed within 2 years after the agreement. So that gets to the first part of all of these bills, which is saying you're not allowed to enter into these agreements with the second part of the bill, which is then on my page 2, prohibits you from putting a lien on someone's property. So it's almost 2 different sections. And-
Isn't that redundant, though? If you can't enter into the agreement, then doesn't that cover everything?
So what this is saying is that an unfair agreement, we're talking about, we have that 2 year, the services have to be provided within 2 years. And if it is not, that is one characteristic of it being unfair. And then when you look at A, B, and C in that subsection, one of those then has to be true for it to officially be designated as an unfair service agreement. Because I think in the instance of where we have a legitimate listing agreement that is less than 2 years, and those services are provided less than 2 years, that is a legitimate agreement. And then when we look at A, B, and C, those are the additional characteristics that, again, what we see in these agreements is that they are 40 years long, but they run with the land and create a lien on the property when they're recorded. And so that's really what we're aiming to eliminate, is when you have agreements that are 40 years long, services are not being provided within those within those 2 years, and they run with the land.
All right. So now, so you got gates. In effect, you've got gates. The first gate is that the agreement is more than 2 years long.
Mm-hmm.
I could conceivably then write one of these crazy things that's 1 year and a half, and it'll never get to the other 3 gates because it passed on the 2 years. You don't want it to pass at all.
I think if someone were to write a listing agreement that were 1.5 years and they were providing those services, I mean, we wouldn't have an issue with that because they're making an agreement with that person, and it's not creating a lien, right? I mean, that's the key part. It's not
But
creating.
you don't get there unless you fail the first question. The first question is it more than 2 years? No, it's not.
Right.
And then you don't go any further. The way this thing is written, it needs to be and must have, not
Right.
this is the first gate and then you don't get to the other gates.
Yeah, I see. Okay.
Okay, so Keith?
Just to kind of pick up on what Rep.
Yeah.
Spears was talking about. So if the lien gets recorded by the Register of Deeds, there could be no limit on the lien, right? So even if the agreement is less than 2 years and the lien is filed, it doesn't mean the lien goes away at the end of 2 years necessarily, right?
Right. And I think
That
the
would be a
reason
problem.
the reason why we have that last section is to ensure that the individual has the ability to remove that lien if it is still on their title. And so it gives them a process. It spells out a process that allows for them to do that.
Right. Well, didn't we just solve this problem with liens that are what was that with the mortgage? What did we end up doing with that mortgage? What was the language we put into that bill? I'm looking at you. Yes, right. Yeah. Why don't you come over and take a microphone? Take anyone. So what did we end up doing? Was it saying that if the mortgage was satisfied and it just hung out there? What was our?
I think you're referring to House Bill 437, Representative Boyd's bill that dealt
Right.
with unjust discharged mortgages.
Discharging
Yeah.
a mortgage.
So if a mortgage didn't have a maturity date currently under New Hampshire law, it would be discharged 50 years after.
Isn't that
recorded.
discharge?
But
Isn't that mortgage considered a lien?
Isn't the mortgage considered a lien?
Yes.
Yeah.
Yes.
Yeah.
And yes, so we create language that this is a process to discharge it.
Correct. Yeah,
Okay.
it refines, it amends the statute to if the bill passes, any mortgage recorded that has a maturity date would be discharged 5 years after that maturity date. And any mortgage that did not have a maturity date recorded, it would be discharged 35 years after the date it was recorded.
Right. So could we just piggyback on that and just simply say that a right to list is an illegal document, and so therefore all the rights and privileges of that person to get it expunge, just like a lien a mortgage that has been satisfied? And I know you're not a lawyer.
Yeah, I'm not a lawyer. I would look to the advocates of this bill
Yeah.
to see what their thoughts would be.
Okay, how many lawyers do we have in the room here? I see we have one here, but I'm sure he wants to stay out of this one. AG one is it? Okay, so the question is something. Can we just do something simple like that? It is illegal to is a lien, right? It's you can't lien it, whenever, and that and then that statute has a process in which you go to the court to get it expunged. If I remember, you have a
It does maintain ability to go to a court,
which
Yeah.
is the same,
court's rights.
which is the last third of this bill, which is how to get it removed. So I just hate reinventing the wheel.
To just address that, I mean, for the record, I don't think we are reinventing the wheel in the sense that we have passed this legislation in 30 states.
No,
and
no,
it,
no,
it was
no. New Hampshire.
right. I
Okay,
understand.
we're talking about New Hampshire now. In terms of what other states is, there are plenty of times I've looked at other states, and I would say is that was a piece of junk, and no, we're not going to pass that in New Hampshire. Okay, so I'm not just because something happened in another state does not mean I think it's a good idea for New Hampshire. I think we want to make it simple and straightforward, easy to read, and not something that's just going to require a lawyer to explain it. So I guess my druthers would be to try to figure out how to piggyback that process and just make it illegal, period. Okay. Now in this case, now it gets back to, do you put it under the Consumer Protection Act? That is a violation of the Consumer Protection Act to attempt to record one of these liens. Okay, the problem with the Consumer Protection Act is that it really is not designed to tell people how do I say it? It's designed to make you full, or economically get your money back. That's the purpose of the Consumer Protection Act. This is a criminal act. This is criminal. That
But
someone,
it's also the idea that you should get your property back without a
Right.
lien on it. So you are getting me a whole
right,
by
but the
having that
Consumer
removed.
Protection Office can't get people's property back. They would need some other language to actually pursue that, and I can't imagine the Consumer Protection Department would want to get in the middle of this nightmare. Even though I think Brandon did say he was in support of this bill.
May I address that?
Got to be a simpler way to do this. Is he? Yeah, I'm sorry, but he wasn't looking like he wanted to get involved. But
J.R. Davis from the Consumer
yeah,
Protection
why don't you come
Bureau.
over here, take a chair, and
Mr. Chairman, I'm a hired man. I'm subject to authority.
yes. So obviously you can't say anything unless you were been told that that's what to say, right?
Given the fact that my bureau chief was in favor of the statute, I can tell you that that's the case, then we remain. If that's the case, then we remain in favor of the statute.
Right.
I have not examined the bill, so I can't tell you that I know everything about it. I've just been listening intently while I was otherwise reviewing a condo application this morning. But if something is declared to be an unfair or deceptive act in commerce in any statute in New Hampshire, contrary to RSA 358A, that's the Consumer Protection Act, then the Bureau and private litigants have jurisdiction. Because remember, we have,
Right.
unlike some states, your private cause of action
Private
under
cause of action,
Section
correct.
10. Don't quote me, I'm doing this from
Yeah.
memory.
Yeah.
And so, not knowing the particulars of the statute, but knowing the concerns that they're involved, this would potentially afford the ability for a consumer not only to sue for money damages, but also to ask for equitable relief from the court to strike the lien.
Okay.
Now, I don't know all the details of the statute, but
Right.
I think that this is, and I mean, when I was in private practice, which wasn't that long ago, and I was in private practice for a long time, I can advise that there has become a real problem with people entering into various types of contracts that are service related, and then liens being recorded, and it's causing it has, at least with some of my former clients, caused some problems. Fortunately, I was able to take care of them each time because we were able to make appropriate legal threats, and people decided it wasn't worth their while to fight about it. But that I know of situations where that wasn't the case, and some amount of litigation was involved that, because of the absence of a clear limitation, would have perhaps made all the difference in the world. But I'm
Right.
not familiar with the particular statute.
Yeah, that's fine.
Good, Bill.
Thank you.
Thank you.
Okay. So what is the critical differences between 164 and the main statute?
So I think we're talking about just some of the verbiage, where we're talking about some of the definitions that are in there. They use long-term agreement.
Right, and I like the future right to list.
Right. I think if you were to compare and contrast the two laws, there are a few differences. One difference that I think is something we would consider if you look at the main law, when you look under Section 2, prohibited agreements, so 2 and then 2D, where it talks about obligate the owner to pay a fee or commission. So that gets into where these agreements have a specific percentage, that an individual may have to pay. And I think what we've seen is this goes into the example that I brought up at the hearing, where you have an individual who has signed one of these agreements, they pass away, and then the service provider, so whoever is has gotten this individual to sign the agreement, goes to the estate and says, your father, whoever it was, signed this agreement. You have to now sign this agreement or pay. And what we've seen is, say, a 3% penalty on the home's value. That's what we've seen. And so that's language that's in there to more specifically speak to.
In the main one or yours?
That's in the main statute.
Okay, so that's a good thing.
Yeah, so we haven't vetted that language with some of the other parties. If that's something that you wanted to consider putting into ours, I don't think we would have any opposition to that. Of course, we'd want to work with Mr. Quinn and the others to ensure that would be okay with them. But effectively, these laws are the same. I think what actually adds some of the length to our bill is you look at some of the exceptions. We have exceptions in ours to make sure that we're not being too broad with our legislation. And then the other piece is that we have a criminal component to ours in Maine, and this just goes down to the state. In New Hampshire, it is a misdemeanor if you commit a deceptive practice, which this would fall underneath based on my conversations with the Attorney General's office. In Maine, and I think in other states, that's not necessarily the case. And so that's part of why this lives underneath that statute, because this would be considered that. So that's really, when you're adding to the length of the bill, it's really because of the exceptions and then the criminal component to it. But effectively, all the other language is the same. It's just worded a little bit differently.
Just a quick question. Who are the people that are offering these agreements? Are they real estate agents, or are they just anybody? Because I don't see how, unless they're a real estate agent, they can't do a listing.
Right. And I may defer a bit to Mr. Quinn. I know he's not sitting back up here again, but I think that's part of the problem is
But
that
he did state clearly in his testimony
right.
that it would be a violation of someone's real estate license. So the question then is, yes, that anyone that no real estate agent who's licensed in New Hampshire would attempt to do this in the first place, which has always been one of those things why it's nagging at me. Why are we doing this? Because it shouldn't happen. So the question was that when the organization that seemed to be doing it is that it was a real estate internet company. And so they weren't licensed agents. Is that correct? Am I saying that correctly?
Yeah, I
That
think the what-
they weren't
what-
actually licensed agents, so they wouldn't even give a rat's ass about our,
Right.
our real
So-
estate license
So
requirements.
I think what we've seen is we've seen, and I hesitate to use individual companies' names in official testimony, but when we've seen companies try to do this, they're not New Hampshire companies. They're more national companies that are operating and trying to work in as many different states as possible. And what we're seeing is that they're trying to get folks to enter into these agreements, and their goal is not necessarily to perform the services. They're not in the interest of actually acting as a real estate broker. If an individual wants to sell their home, what they're really trying to do is go down that scenario that I just walked through before, where you have an individual who is now looking to transfer their property, whether they've passed or they're getting to an age where they're looking to pass to they're transfer their property to a family member. That's when these companies are able to kind of make their dollar, because they come in and they say, if you're going to do this transfer, whoever this new person is who's taking over the home has to sign this agreement. Otherwise, we're going to charge you a 3% penalty on the home, and that's really the issue that we're getting
No,
at.
we get that, because we had another bill with hotels that it's all about the settlement money. And so, yeah,
The starter of this, the inventor of this, according to what I've been reading and what I saw in the law cases, in these lawsuits, is MB Realty. They are not a fly-by-night operation. They're a huge real estate funding operation.
right.
And they had a couple of people invented this and thought it was great. And they're out of Miami. MB Realty.
What is a funding company?
They said they loans for big construction.
Okay.
So they're actually a finance company.
Yeah,
That-
so I think
they're
that more
finance,
describes
and that's
them.
why they're involved in, they're
That's why, although it's not, some of this looks almost like, and I'm going to say it but it's not, I want to make sure, almost looks like a reverse mortgage.
Yeah, well, it has that feel to it, right?
Yeah.
It has a feel to it. I mean, I was thinking it's almost like the, your prepaid funeral services, because you're prepaying for a real estate agent, ahead of time. But of course, that real estate agent is probably going to, if they really were making the deal and really were, they would still get their commission over and above this whole agreement. So that's what makes this really flaky. So does anybody know whether this is under in Maine, whether it's under the Consumer Protection Act? Do we know did anybody know the Maine tax, this numbers? Probably, we don't know. We don't know.
I don't know that.
We don't
And
know
I
what
would
it
just
is.
assume that they don't have a similar criminal statute to ours, and that's why they didn't have that classified that way.
So how about we just take Maine and change it from long-term agreement to future right to lien? And we'll just take this statute, and I know it's still got the 2-year thing in it,
It does have it? I thought I couldn't.
Yeah, it's 80
Oh, yeah,
point-
it does.
but it's just that way we'll just say that, oh, we got a hand up. So good, great.
John, can you just repeat the sentence that you said?
So I would,
Take the main law and,
in definitions, number A, long-term agreement. Instead of being long-term agreement, we're going to call these future right to list.
Thank you, Mr. Chair. Kate Horgan from the New Hampshire Association of Counties. I have not seen the main statute, but the registers would just like to make sure if there is a filing component, it is not their job to determine whether or not something is fraudulent.
Right.
It's just they file it or they're allowed to file it or they aren't.
And I think that your court was also involved in this language, because I do not see anything in here that affects. recording.
Wonderful. Thank you.
So what do you guys? Our bill is too long. I was going to go with the main, and just instead of calling it a long-term agreement, have future right to list. I'm not. As far as what I see was a violation of this subsection 2 is a violation of the Maine Unfair Trade Practice Act, which would be our Consumer Protection Act. Right? Would you agree with that?
sorry, Mr. Chairman. I'm not a member of the Maine Bar, but I have worked with members of the Maine Consumer Protection Bureau.
Yeah.
My understanding that under their Consumer Protection Act, they do not have criminal jurisdiction.
They don't, even though we have it under ours.
That's correct.
So we're better than they are in that sense.
Well, I don't know that I'd limit it to that, Mr. Chairman, but I would agree with you that although we don't present that many criminal indictments or complaints under the 358A, because we
Right.
often find that the same conduct fits under the criminal statutes, that it is extremely important enforcement tool for the Bureau.
Okay. All right. So how people feel like this? Just take the Maine and we'll switch it to New Hampshire Consumer Protection Act. We'll leave it under the Consumer Protection Act, but we'll call it the future right to list.
What will you give me if I don't fight over the 2 years?
A lollipop?
Uh,
Nah,
any
I'm
portion of the
teasing.
state
I'm sorry.
for right.
Sorry.
The idea if we have, I'm a big believer of uniformity in statutes, so that if we have, by doing this, if we have uniformity, so that more apt to people say, okay, we know that law, we know because we've seen that in other states. So, how everybody ready to feel comfortable with that? Yep. Go ahead. Yep.
Thank
Okay.
you. It says, I'm just curious, it says this is for residential real estate. Is there any reason why commercial would be excluded?
Yeah, thank you for the question. I think we've seen this in the practice of residential real estate. I don't think we have any evidence that this has been tried when it comes to commercial real estate.
But if I own a small commercial building, wouldn't some of the same issues exist? So I don't know if we have.
But historically, we don't like to meddle into business to business.
Okay.
Okay, that we're thinking there are big boys that can afford lawyers that would make sure they don't make a.
But if it's like a small little standalone, retail shop.
That is true, but we would assume that they are to be
No,
running a
okay,
business.
no,
They're
no
smart
problem.
enough to
All
not
right, no
not to get
problem.
into one of these
Thank you.
unless they know what they're
I just
doing.
didn't know if
Yeah.
we were going to
No.
limit it to residential.
Yeah.
Okay, thank you.
Keith.
Oh, thank you. I'm looking at the main language, section 4. It says unenforceable recording prohibited. So tell me about the recording prohibited part. We just heard there's a concern about the registers of deeds.
Yeah, thank you for the question. So I'm not familiar exactly with Maine statute when it comes to the statutory obligations for a registrar of the deeds in Maine, and they may have different obligations in Maine. I know in New Hampshire from the testimony of Ms. Berube that in New Hampshire they really have no authority to refuse an agreement on the basis of the agreement. I think it's more of a formatting that might be the only thing. And I know other states, registrar of the deeds do have other statutory obligations where they have, I think, a little bit more ability to refuse agreements. But in New Hampshire, that wouldn't be the case. And so I think that may be part of it in the sense that a registrar of the deeds in Maine may be able to refuse one of these versus in New Hampshire, they really are obligated to record it when they receive it, unless there's an error in the actual agreement.
Okay, because it says a person may not record or cause to be recorded. So would you think that means? See, I was thinking that is the person bringing it to.
Correct.
The
That's
clerk.
how we interpret it as well. Yeah.
Okay. But reason why we don't want to take too much action on this today is we want to make sure all the legal beagles have had their chance to review that and the implication of that, so that we're okay with that.
I have one more comment.
Okay.
In reading this carefully,
Right.
if you enter into one of these agreements and it's for less than 2 years, they're going to put a lien on your house. And I'm sorry, but that is wrong. It says the only time it's illegal is if you do it longer than 2 years. If I do it less than 2 years, and remember, the lawsuits were set up or discussed because these people are using deceptive practices and not allowing people to read the contracts that they're signing.
Okay, I hear you. So you want the owner agrees to list the owner's residential real estate for sale with the any person agrees to any portion of the real estate privilege to be provided under this contract may be for more than 2 years after the date of the contract. So we just want to strike all this language then and just say long-term agreement means a contract agreement between a provider and owner in which the owner agrees to list the owner's residential real estate for sale.
I would
With the
take
pro-
out long-term. If you want to define it, but
So we just want to get to the definition being the owner that the
that this real estate
agreement, this agreement is for sale with the provider at a future date. Rephrase that sentence to simply say what it is. So it means a contract or agreement between a provider and an owner in which the owner agrees to list the owner's residential real estate for sale with the provider, period. And then you
Yeah.
scratch out the whole section 2.
Just to jump, I know that was one of the things that we had spoken about with Mr. Quinn. And again, I think what we definitely don't want to do is somehow prohibit legitimate listing agreements. So I think that might just be one thing we want to maybe dig into a little further.
But a legitimate listing agreement would not put a lien on a house. It is not legitimate if they put a lien on it.
Right.
So, Bob, has anybody ever done a listing agreement where the realtor gave them a check up front?
Companies that do that. They pay to list your house.
Really? And that's legal? Well, then that makes this whole bill problematic.
No, they don't put a lien on the house. They give you the money, but they don't put a lien on the house.
Oh, okay. So it just simply means under which the owner agrees to list the resident for sale, and there is a lien. It has to be the word lien has to be in this ban. Okay. All right. So means a contract agreement between a provider and an owner in which the owner agrees to list the owner resident for sale with the provider, and the provider attempts a lien. What? Provider okay, but is the provider places a lien? What is the?
Or perhaps creates a lien. The language that we have
If it's,
in our
with
bill
a
and
provider under the requirement of a lien under the.
I think they had it. The service agreement purports to create a lien, encumbrance, or other real property security interest.
Yeah, because this all keeps talking about the contract. Yeah, so where are you reading that? I'm sorry.
Oh, in the original bill.
In the original
On
bill,
Page 1, line 21. That's that whole 2-year, and they give like Kerry was saying, the gates. Well, C is where it describes the lien or encumbrance,
Okay.
whatever the difference is.
all right.
Couldn't you just simplify the whole bill by saying no service or listing agreement allows for a lien on the property? I
Okay.
mean, that covers the whole thing.
there are some other components. Just if in sort of looking,
But
at
then you could say with an exception of a mechanic's lien.
right, Right. No, certainly, and that's in our legislation.
And that's in here too.
Yeah, I suppose there's also the other characteristics, which again are in our bill and also in Maine, where it talks about binding any future owner not a party to the long-term agreement, or depending on what we use for that phrase.
Maine has a different statute?
They changed what they passed.
Oh, so this is not,
It's not the current, it's not what's in statute.
well, it says approved by governor, June 23, by the governor. Okay. Okay. All right. I'll have a legal beagle work on this. But again, the end of the day is that the owner agrees to the listing for sale and provides, and which requires a lien, or has a, which requires a lien, is what I penciled in. But we'll work on that. All right. So we'll take this up the next subcommittee. All right. Moving right on.
Are you going to prepare something for us to
Yeah,
look
we'll
at?
we'll definitely. It's the good thing about we don't have to have anything out until the end of the last week in May is that we've got time to, we'll work on this language. Okay, next up, Senate Bill 25, allowing credit union members to pay the members of the board of directors for their service as a board member. Is there any amendments to this bill? Okay, does everybody understand what this bill does? Anybody have any questions? I'm not. All right, so the subcommittee ready to vote on it then? Okay, that's the service agreement. So. Cool. Yeah, come back. Okay. All right. All right, so who's on this subcommittee? We have Hunt, Patusek, Post. Well, that looks like all the committee members there.
Hammond, Pressa,
Okay.
Tusick, Hunt, Thaxton, McAleer, Herbert, Spear, and Salvi.
That's a big one. Okay. All right. Anybody like to make the motion on this one? All right. Representative Ammon. Second. And seconded by,
Motion is OTP.
OTP.
all right. Seconded by Representative McAleer. Moves ought to pass. Any discussion on the motion? All those in favor, please say aye. Aye. Those opposed? So moved unanimously. So, two, four, six. Wait, yeah, because Salvi's on this, right? Yeah. Yeah. And Spear and McAleer is here. Okay. And Thaxton's replacing Cole.
Yeah.
So that's 1, 2, 3, 4, 5, 6, 7, 8.
Right, but
And
Thaxton
Herbert.
isn't here.
No, he is. Oh, there he is. Yeah, you're leaning back. Okay, so it's 8-0.
But Thaxton isn't here.
Excuse, right. 1, 2, 3, 4, 5, 6, 7, 8. I did not count Thaxton.
Plus there's 9.
So we're 7.
2, 3, 4, 5. There's 9 on the subcommittee.
There's 9?
Okay, moving right along. Okay, Senate Bill 26, relative to the definition of deposits as they pertain to land sales and escrows of deposits. All right, have we gotten some cleanup on this language here? We got a resolution? You guys have a resolution? All right. Yep, yeah.
Comment.
So you handed me a piece of paper. Was that the only piece you had on that? on the amendment?
No, hi, I'm Matt Mayberry, CEO of the New Hampshire Home Builders.
Okay.
I didn't hand you a piece of paper.
Okay. All right. Sorry.
The in consultation with and thank you for your time today. In consultation with the Attorney General's office, if the committee would so see fit, Chairman, if you deleted section 1 and section 3, keeping sections 2 and 4, that keeps everyone on this side of the table happy. Home builders, attorney generals. This is about the escrow for upgrades.
Right. Okay. So you want to delete?
Section 1 and section 3, because those are just definitions that we already know. So cut down the verbiage.
Okay. Well, that's always good. We like that. Okay. So 1 and 3.
Yes,
So
sir.
Now
And-
the bill is going to be just section 2 and 4
Yes, sir.
and well, then
Please.
5. Okay. Okay. And AG, you're okay with that?
With permission of the chair, I'm going to stand because my knee is
No, that's
killing
fine.
me.
You can pick up the
Thank you.
microphone and just
Yeah,
keep.
I-
You have to keep it close to your mouth. That's the problem. So you just pick up the mic. It's all right.
I'm good at leaning. It's
Okay.
it's just the sitting is
All
the
right.
problem.
Leaning in.
Yeah, the subject to the proviso that whether there is a change in the legislation is totally up to the general court. But should this committee decide to recommend the change,
Yes.
we believe that that would be the applicable way to make the change. That is to delete sections 1 and 3, leave sections 2 and 4. I would note for housekeeping purposes that the amended analysis would then only be section Roman 2.
Okay.
And the committee might also recall that the Bureau mentioned that during the last time that the Bureau mentioned that should the legislature decide to pass this bill as amended, that we think it would be effective upon passage, because we do know that there are hundreds of approved purchase and sales agreements out for units that have been approved by the Bureau but not yet entered into purchase and sales agreements.
Okay.
And we anticipate that quite a few existing,
Well, this
in
is that
development-
construction season. So
yes, that we anticipate that there will be a lot of
Okay.
amendments to existing documents.
Okay. So the one change would be the effective date would be upon passage.
Yes, and again, but
Great.
thank you.
All right. Any discussion from the subcommittee? You can visualize it if you have the bill in front of you.
I
And
have
the
a
only
blank,
thing you need to cross out and change is upon passage. Okay, well, that's true. We can wait until we have an amendment. Okay, we'll wait till we'll have an official amendment drawn up and then we'll vote on it. Okay.
Bureau would like to thank the committee for its time and attention.
You're very welcome. Okay, next up, Senate Bill 52, relative to vault provisions in the New Hampshire trusts. Okay. Okay, who's anybody care about this bill here? I don't.
You're a co-sponsor.
Yeah, must be me. No, am I? Oh, yeah. 52. Okay. But I mean, you're for trust here, right? Don't you care about this bill? Yeah. Okay. You so. Okay. So this bill does not need an amendment. It's good to go. Okay. All right. All right. So everybody okay with that? Subcommittee? Yes, Representative Burrows?
I have a question. Okay. So what if the beneficiary of a trust is also a relative? Dun, 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 dun. Okay. A beneficiary of a trust can't replace somebody and replace them with a relative or subordinate, but
They could, the relative could be a trustee from the beginning.
yeah.
That's the way I interpret it.
S- I'm still trying to.
My understanding is a relative can be a trustee by applying this law.
So if a relative is a trustee, why couldn't they be replaced by a relative or subordinate?
I think it has to do with timing.
What do you mean, to replace, honey? You can't, that would be in multiple, you can't be two people.
Okay, it has to be one.
Somebody else. Yeah, where are you reading this?
The first number one.
Okay.
It's a question of timing. In the first place, when it was set up by the owner. Now it's a beneficiary that's doing it.
Right.
So
Yeah,
Shouldn't be.
it's just changing the title. Yeah.
May exercise.
Hi, why don't you introduce yourself?
Oh, I'm sorry. Heather Augmanson. I'm with the New Hampshire.
You have to speak really close to these
Okay.
mics.
Heather Augmanson. I'm with the New Hampshire Trust Council. I work at Jordan Park in Portsmouth, New Hampshire.
Could you speak into the mic? It's hard
You
to hear. you.
really have to speak like you own, like it's in your mouth.
Okay. Can you hear me now?
Yes.
Yes.
Okay. My name is Heather Augmanson. I'm with the New Hampshire Trust Council, and I work at Jordan Park in Trust Company in Portsmouth. So I think what you're referring to is the beneficiary's ability to remove and replace a trustee, correct? So you're speaking to when there's a trust in existence and you have a fiduciary who's already a relative.
Yes.
Okay. I'm going to go out on a limb and say that it would have to do with timing. So if there is a trust in existence and a fiduciary is a relative of the beneficiary, but perhaps maybe that beneficiary's rights hadn't vested yet. So this is a scenario that would only happen were some event to occur that would change the circumstances. Okay. And this provision really relates to preserving, removing the property, keeping the property out of a beneficiary's taxable estate. A beneficiary who has the power to remove and replace with somebody who's related or subordinate would then be deemed to have a general power of appointment. So this works to avoid that circumstance. Really, this is working if the trust were to not have that language embedded in already in the document.
Can I give a real life story? Because that's how I best would understand it. And this actually is a real thing in my family. I hope you're not listening. But they're in California. My cousin became the trustee of her mom's estate. There was a family feud. I don't need to get into it, though it is pretty interesting. And so she said, I don't want to do this anymore. You know, I just don't want to be in the middle of this anymore. So she stopped, said, I'm not going to do it anymore. And she replaced herself with her sister. Is that okay?
So this is not barring anyone from doing this.
Okay.
If you were to have an estate, taxable estate, you would want to avoid this result. If you don't have an estate, taxable estate, there really is no harm provided the trustee is upholding its fiduciary duties. So the language in this in this bill really speaks to an estate taxable estate. We're talking about estate tax code is what we're speaking to
Okay.
here.
Okay, thanks.
Great, thank you. Okay. Everybody in the subcommittee are okay? That Representative McAleer?
Your comments on this, Bill,
Yes,
I assume you support it, is that correct? As
we,
written?
we do. Yes,
Okay.
This is a trust council bill.
yes.
Okay. All right. Anybody wants to make the motion? Representative McAleer? Okay. Second, Patusek. Any discussion on the auto pass motion? All those in favor say aye. Aye. All those opposed? So moved unanimously. That's 8. Okay. And last but not least, relative to charter bank lending limits, Senate Bill 85. Okay. Assume no amendments. We're all good. I guess I would be to make sure everybody understands the reason was that the fear of monopolies, I guess, or someone controlling too much of the market, and that's why. Yes, I was here when it was a lowly 10%, but we had a lot more financial institutions back then. And okay, but weren't you in the banking department? Didn't you do banking? Yeah, you probably were around when we went to interstate banking.
You're representing this bill?
Yeah, we do have. We have
A question in here, is there, I haven't looked at the bill that carefully, but is there anything in the bill that says that if they go over 20% or whatever, that they can't lend it to a board of director or something like that? Nothing in here that limits that?
There, I believe there is federal regulation that deals with,
Okay.
self-serving.
Yeah. The essence of this bill is just for New Hampshire chartered banks, of which we have 16. Right now, there's 2 components to the bill. The first component, it deals with legal lending limit. Right now in New Hampshire chartered banks only, they can only lend up to 15% of their capital to any single customer, not just one loan, but in total.
Yep.
However, their neighboring a bank down the street that's chartered in another state, Maine, Massachusetts, or Vermont, has the ability to lend up to 20%. So it's a competitive disadvantage. So if a New Hampshire charter bank gets up to that 15%, what they'll do is they'll tend to partner out on that loan, that current loan, generally out of market, so they don't lose that customer. The other aspect of the bill has to do with what's called de novo status. Those are new bank charters in New Hampshire, New Hampshire chartered new bank charters. The FDIC's de novo status is 3 years. New Hampshire statute currently is 5 years. So all that does, that component of the bill just aligns it with the current FDIC.
Gotcha. Okay, thank you.
You're very welcome. The FDIC is 3 years, correct?
So what? Yeah, federally chartered. What is their limitations?
Was
What's
that-
the, currently federally the feds?
So the feds, I believe, is 15%. Yep. But it does allow states to adopt their own.
Right.
And actually 15% is, geographically is an outlier. Nationally, it's an outlier. It's low. Our surrounding states are at 20%. If you look at, I think
As state charter banks.
for state charter bank.
Right.
Yeah.
No, I always say that the big discussion is really we want banks to stay state charter. We want them to be in, and that we don't want federally chartered to be appealed to change your charter. Okay, so if the feds are 15, so now in this case we're saying this is a sweetener to stay a state charter bank.
I think that's a good way to characterize it. Yep.
You gotta take the mic, Chris.
If I understand what you said, you have 16 of these state chartered banks,
Correct.
not all of which have the same limit.
No, so our 16 state chartered, New Hampshire chartered banks
Yep.
are at 15%.
Okay.
However, we also have Maine chartered banks in New Hampshire doing business, have branches doing business in New Hampshire. We have Massachusetts chartered banks that are doing business here in New Hampshire that have branches, and we have Vermont chartered banks that have branches and doing business in New Hampshire. They are all able to lend out at 20% of their capital. So what this bill does is it brings New Hampshire charter banks
To 20.
at that level. Correct. It's leveling the playing field. It does also give them the ability to go another 5% if that additional 5% is fully secured. Now, just because we have a limit of 20% doesn't mean that banks are going to. They still have loan committee. They still are examined periodically for safety and soundness. They're not going to be making risky loans if they feel they could impact the safety and soundness of their institution. So there's still underwriting and there's criteria in place to ensure that they're still making safe and sound loans.
Well, I have another question, which I think I know the answer to, but can they have federal and state charters?
You have to pick your regulator. However, so I think I know where you're going with this. If you are a New Hampshire charter bank, you also have FDIC as your federal regulator, but your prudential regulator is the New Hampshire Banking Department. You are examined as a state charter bank by both every 18 months or so.
Thank you.
Yep.
Okay, I just have a question. Thank you, Chair. My question is, we are changing the limit from 15 to 20% to be in line with other bank out of states. So what are the measures we have taken in place as compared to other banks out of state to manage the risk, as well as what are the things in place that we will not have any issues down the line? I asked the question last time. I didn't get the enough answer.
Yeah, I think, again, I think that speaks to a comment made earlier. Banks, even though this is giving them the ability, doesn't mean they're going to. I think what it does, because they still have, and they still have loan committee, they still review, they are still examined by the banking department. They are still examined by the FDIC to ensure they're not making, they're not putting the safety and soundness, the overall safety and soundness of that institution at risk. So there is still examination and oversight of the institutions.
Just a follow-up. So they are following the same process as other out-of-state banks.
Correct. They still have the FDIC as their federal regulator, even though they are a state chartered bank. They'll have their state bank regulator in those states examining them, as well as the FDIC.
Okay, thank you.
You're welcome.
Representative Allen.
Thank you, Mr. Chair. Thank you for taking our questions. I'm just trying to understand it for my own. This might be a dumb question, just heads up.
No such thing.
So page 1, line 6. So in the context of fractional banking, what does what is included in the depository bank's capital and surplus? How does that relate to? So you have 20% of this pot,
Yep.
but banks can lend out based on, fractional lending, right? Does that multiply? Is there a multiplier there, or how does that work? I'm just trying to get my head around it.
That's a great question that I'm not sure I'm able to answer. I'd probably have to get one of our bankers who are very intimately familiar with how that actually breaks down.
Okay. I'm just be interested in that.
Yeah,
Thanks.
absolutely.
You'll get back to him on
I
that.
absolutely will.
Okay.
Yeah.
Okay. You're okay to go with it before? Yep. Okay. All right. Who would like to make the motion? Okay. Representative Salvi. And second, Representative Petusek. Who's to pass? Any discussion on the motion? All those in favor, please say aye. Those opposed, so moved unanimously. Oh, that's not mine. Those don't look like my grandkids.
That's not mine. I got mine in my pocket. This is this.
Somebody I picked up somebody else's. I don't know.
That's mine.
Oh.
Made its way down there.
Get, not that I'm supposed to be able to do this, but going back to our unfair residential real estate agreement. So the problem with the future right, that still had that 1 to 2 years. And because we want to make it an outright prohibition to be doing it, it's going to be prohibition to list.
A listing that required somebody to put something on a lien on a house.
Right. Right. So that's what I'm saying, but I'm going to now call it a prohibition to list. You cannot list if you're going to put a lien on. Prohibition to list would be is if you requires a lien. Okay, and we'll just run this by, and like I say, if the devil's in the details when we get it printed, get the amendment drawn up, and then we can see if we can feel comfortable with it. Other than that, so we just have 2 more bills we're going to do today. We have some more tomorrow. And then turns out we're not having a session next Thursday. So I'll try to spread the bills out. Yeah. Yes, Representative Spear, you have a pained look on your face?
Yeah. Is it possible to sign a listing agreement, not putting a lien, for 40 years? And does it mean anything?
Yeah. Right now, you could, when you do a listing agreement.
You could do that.
In there is absolutely, that's a key component of the listing agreement is the term.
Right.
Okay, because, you're.
And
how
I'm
long-
used to
how
seeing
long-
like 3 months or 6
How
months.
long am I locked into this realtor? And usually you don't want it too long.
But we don't want to
Because
say
you might be
what that is.
disappointed with that realtor and you might want to shop around and get a different one.
Right. But we don't want to say anything about
We're
limiting
not in that business. All we
Okay.
care, this whole bill is simply this obscure concept that somebody would actually take a lien on the property. And worse of it is, we didn't even know how much they got paid for doing it.
This Thursday, we have a session.
This Thursday, but next week we don't. So in terms of how many days do people want to come in next week? And 5. I know you don't want to come in 5. On one day?
I got something going on Wednesday.
So what were you thinking?
I haven't really. I mean, I know. I mean, in terms of, I think I still have, we could do Tuesday. I think I actually, scheduled things on Tuesday already. The ambulance, which is gonna be the Big Bear.
On the 20th?
Okay. And that's on that's the 13th?
Yeah.
Right.
Oh, we're talking about the week of the 12th, okay.
So let's do Tuesday, Wednesday, and I'll try to, try to get everything scheduled in terms of subcommittee, so we keep the ball moving.
Okay.
And we can do is yeah, let's just see how well we're moving the schedule. I won't bother with Thursday.
Do you have just a rough guess when we're gonna be done with everything in Commerce?
We have to have everything out by the 29th
Okay.
of May. And that, at that point, we're supposed to clean out our boxes.
Works one more time, I'm gonna lose it. Not from you, not.
I know, it's just, it's the chairman's meeting, they spend the whole time talking about.
They told us a couple of times.
I guess they're really worried about whether we really get it.
Felt like I was in an opera room.
So how about doing Thursday rather than Wednesday? Do Tuesday, Thursday
Tuesday, Thursday?
next week?
Then you're gonna have to stay over.
Yeah, that sucks for us, and we have to go back and forth.
Who's us?
That's me.
Do you stay overnight too?
Yeah.
Really?
If they're consecutive days.
Right. Well, how about Wednesday, Thursday?
Now I gotta change it again.
What do you have to change?
I've got a car appointment
A car appointment, right?
all the way down in Nashua. So
Holy moly, Nelly!
All right, so you're talking about the 14th and 15th.
we're already scheduled for the 13th.
Right, I'm already scheduled.
So let's do Tuesday, Wednesday.
Okay.
I think Tuesday, Wednesday, we are used to it.
Okay. All right, so I'll schedule, all the different bills so we can just catch up and see where we are. So,
After taking propofol, can you drive?
Taking what?
Propofol.
What's that?
That's the drug that killed Michael Jackson. They're gonna be giving it to me.
Dental?
What?
Dental?
Minor surgery.
But he took a lot.
Yeah, I'm not planning on taking a lot, so.
I can do Tuesday, Wednesday. I'll drop my car off.
yeah, drop your
Tuesday
car.
afternoon,
There you go.
And I had a ride. Got a car at,
You going to lunch?
Yes, I am.
All right, I'm going to lunch.
Siri, power down.
Okay.
We want to check and make sure we got the date,
So,
7 in the morning, or the 13th all day,
yeah,
and there you added another one.
I will take care of that. Yeah. Okay, we'll open up the subcommittee. And first one we're doing is Senate Bill 162, which is
Bill.
this is a business bill? It's still business? Yeah, it's still business subcommittee.
Yep.
Okay, so Representative Walsh has requested that we would all hear how she could try to salvage this bill. 162? Yeah, she wants to try to salvage it.
Yes. First of all, obviously the Senate is in favor of it. The governor is in favor of this. There is an amendment that's coming from Senator Birdsell, and at this committee meeting, I'm sure we're all willing to hear input as to suggestions for the amendment. One of the things that will be in the amendment is that what you were talking about, Representative Thaxton, is that the seller be held harmless should it be discovered at some other point that the person, the buyer, is a bad hombre. So, and defines this, who, the person that's the enemy of the states, for lack of a better word. And I believe that they're also going to take out the leasing part of it as well. So,
So you can lease?
yeah, yeah. I don't have the paragraph in front of
There's a
me. I'm not
reference to
going, I'm just
leasing.
saying in general, these are the things that could be taken out. Now, if there's,
No, but
other
it
suggestions.
it doesn't address the problem I have, which is this whole idea that you're gonna you're gonna go down and have it certified that you're not a foreign citizen. I mean, and then send this off to the AG's office, which is just gonna get stuck in a file box, hopefully not cylinder file box, in which you hope that someday, if it turns out that that person really was working for the People's Republic of China, that you could prosecute them because they signed this document and said that they were or were not a member of the Chinese.
So I'm just trying to understand where you're getting at. Are you saying that we can't control the AG's office?
No, I'm saying the AG's office is not going to do anything with it. All we're doing is asking.
We had a representative
asking-
here from the AG's office, so I think that it is of importance.
That was
to them as
true.
well.
We did. It's true. But
I mean, I can only state that I believe it is of importance to their office as well,
okay. Yes.
And you'll all forgive me, but if you already had this part of the conversation, but as a real estate licensee, my personal concern and my concern for every real estate licensee in this state is we are oftentimes held responsible for things that occur in transactions that we should have known, could have known. And so it's not clear to me that we do not have, if this law were to pass, that we would not have some burden of proof or responsibility to determine whether this person was Chinese, Syrian, Russian, and are they good Russians or bad Russians? Because we have Russians in the house. So that's further concerns me. As I said earlier, before the meeting opened, the people who own the Chinese restaurant next to my office pay taxes to the United States government and are United States citizens. But they also pay taxes in China because they have family in China, and from the perspective of the Chinese government, they are Chinese nationals. The mere fact that they live here and make money here doesn't mean that the CCP doesn't get its VIG. And I know this because they don't have a fax machine, and they come over and fax their tax documents back to China on a quarterly basis. That is a very unforgiving, very unfriendly regime. I get it. But I also understand on a personal basis that this may never really be enforceable. That's my concern. And I don't want the responsibility as a real estate broker that I didn't enforce this law. I can't tell by looking at you whether you're Chinese or not. I think I can, but maybe I can, maybe I can't.
She could still be a commie, you know. The other thing,
No, I think she's a Republican, so you're safe.
well, so they come in all different sizes. The other thing
Some
is,
people, that's worse.
the other thing is for a real estate agent, they're actually not allowed to discriminate on anything. So in order to do this, you're breaking real estate laws.
Well, I'm sure that with the AG's office involved, there wouldn't be any laws being broken. And besides sellers, I'm sure that the senator would be open to including real estate agents to be held harmless as well, should something be discovered. So all I'm asking is that we wait for the amendment that's coming.
Okay, fair enough. We'll schedule it again.
Okay, thank you.
So it will be available next week?
I hope so. I will ask the senator to please. They're working on it now, so I would assume it would
Okay.
be.
Can you just
So-
ask them two things? I'm sorry.
Sure.
Like, I mean, there are drones, right? They could pick up information. And what if somebody is 10.5 miles away? I mean, it's not going to really, what is that going to do?
Yeah. So for the record, when Representative Walsh said to me, what could I vote for? And I said to her, if the bill simply says that it is illegal from that a citizen of these listed countries here buys land or anything the lease, you just got to get rid of the leasing. Leasing is,
Yeah, that's all.
but
that's all.
they testify that they said absolutely, someone could steal all kinds of information in a matter of hours. So yeah, you could go stay at a hotel room and send your drone up, and then who knew that Manchester had a military base?
Don't they keep their information secure? Oh, yes.
Well, that obviously, notwithstanding, my problem with all this legislation is that it's really not us citizens or representatives of the state have a responsibility that we need to do with. I would sure hope they do, which is make sure people don't steal information. I mean, I read Tom Clancy novels and every month, and it seems like we have good, you would make sure that our military bases are secure. And in fact, frankly, passing this legislation implies that we don't trust them doing a good job of maintaining security. But having this, so according to here, it says we have it's the 197th Artillery Brigade has a readiness center, which I assume has lots of high-tech communication they can call up and find all their people quickly.
French 75.
So I said to her, if you want to make a law that says that those people are not allowed to buy, throwing out enforceability, throwing out, any logic about why or whether it's right for us to ban people from buying something in New Hampshire, the constitutionality of that. But that would be the one thing I could, that's fine. If you want to say that it's illegal for anybody who works for the government in official capacity or who's an employee or agent of a foreign country of concern, that they are barred from buying land in New Hampshire. I assume that they didn't do that because it would be a constitutionally problem from doing that, but to have all of us New Hampshire citizens, that when we buy a new home or buy our home, and that we have to, just because we're within somebody's ability to say you're 10 miles from one of these facilities, that you are required to fill out an affidavit and have it certified, is just, it's beyond regulation. I mean, to me, I can't even imagine that we would make our New Hampshire citizens do that.
How would you think that anybody would, like Representative Thaxton was saying, how would we know? How would we know something? How would a real estate agent even know?
Exactly. There's no enforcement. It doesn't mean anything. All it says, and why? And who's to stop the person from lying? First of all, because they lie, they did it. They got in there. They rented the property. They went to the hotel and sent their their whatever listening devices up and got all their information, and they pack up their bags and they're gone. I mean, how does this do anything?
Also, I don't know, did you read about, it was in the paper, they have found Russian spies living in the U.S. and I forget.
There's a whole television series.
Yeah,
there,
yeah. Well, the
right.
Americans, but I mean, that says
And
it
you
all.
dare to call it Americans.
But I mean, that was fiction, but there was some stuff that was real. I remember there was a woman
Oh,
who
I'm sure it's real.
got close to, I think she was living with a guy who had information and she was ferreting information
Yeah.
that way. So this is just,
Yeah, I heard recently that yes, the Russians were going to kick, that even though it was not very successful under the Soviets, that the new Russian regime has decided that they're going to reinstate the program, and they're going to try to get American citizens to do all this. And as far as I'm concerned, that's our military's obligation to make sure they don't get any information. Not our job.
So I had a question about, I'm interested in Portsmouth Naval Shipyard, half on the seacoast, half in Maine. And the senator mentioned that,
I thought it was all in Maine.
the main, no, there's always fights about that. She mentioned that the main side of the shipyard was quote protected, and I didn't write down specifically what Maine did to protect the shipyard on their side. So I think she mentioned that Maine.
Maybe
or
because maybe
other
Maine has
states
passed this
passed
legislation.
Something.
Maybe she thinks they
Maybe
passed. Yeah.
someone could figure out what happened in
So-
other states or Maine.
My preference is to retain this bill and keep working at trying to find something that will work, but I'll give you another week.
Thank you.
And so, does anybody else would like to weigh
Yes,
in
I'm
on
taking notes.
discussing this bill?
Just a quick comment.
Representative Herbert is first. You got to turn your mic on.
To my knowledge, Trump Towers, the Russians have an entire floor. Okay, I mean, I'm not making it up. The guy, they were actually doing business there.
and I'm sure they went to the bathroom in Mar-a-Lago where all those secret documents were.
I don't know. No, it's if you want to, you can read the book. But there's
Sleeping with the Chinese spy.
the guy. It's by a guy named Perkins, who, by the way, grew up in New Hampshire.
Okay.
Okay, so I'm not holding that against him. But for a long time, and as far as I know, they're still there. I think they're actually doing a legitimate business for the Russians, and they're doing solid for Mr. Trump by paying for an entire.
Let's not get partisan, because that's the problem with this bill in the first place.
Okay.
Okay,
Just-
yeah, Representative McAleer.
My comment was, and Kerry was at this session as well, and there were 3 people from the New Boston, again, space,
Yes.
whatever, and they were for the bill, but they basically said it's meaningless. It's not going to do any good. That if they want to do something to get that information, there are many other ways that it would work. So, although they wanted the bill, it just wasn't going to close the door, so to speak.
be involved in crafting it, you know?
Actually, they're not the ones who should be involved. It's the CIA, and we have reps not too far from here that can come in and tell us what the real problem is. This bill doesn't address the real problems at all, and the CIA can tell us. And I have had many classes with them, and this doesn't represent what happens.
Aren't some of them Russians, though, that have infiltrated?
I have no idea what you're talking about. But this bill doesn't reflect anything of the way that they get the data.
Okay. You got your marching orders.
Thank you all for
I would,
sharing.
I haven't taken a straw vote, but I'm venture to think that most people would think retaining this bill is a good idea.
I'll second the retention.
Okay. We won't do that today. All right. Last bill of the day.
Yep. 280.
You just, yeah, so just right. All right, so this is a pretty straightforward bill. Representative Patusek is a co-sponsor. Okay. So is it, everybody understand what this is? It just brings back, it sunsets the sunset. It reverses the sunset. It reverses, okay?
We make it longer, just indefinite?
Yes, that's what we'd be doing. There's no more sunset. And as the person who probably thought the sunset was a good idea, I always like when we get involved, and this is a business to business legislation, by the way. So normally we would not do that, but in this case, we put the sunset so we can see what the effect is and how it worked, and it seems to be very workable, so we want to bring it back. Okay, so Representative Patusek, seconded by Representative Burrows.
I'm not on that committee, is that okay?
Oh, okay. Representative Spear.
Representative Spear, she can second it.
Okay, moves ought to pass. Assume we don't need any amendments on it?
I
Okay.
still have a question on that bill.
Yes.
Thank you. I still don't understand, basically, if we are putting the responsibility, means the hotel owner is going to have an agreement with any food delivery person, right? When they try to when we order a food,
When you order the food
Food.
through
any DoorDash
DoorDash,
or whatever it is,
okay,
they
so-
should have the agreement with that restaurant.
they have to have an agreement with that
And
restaurant.
how we will come to know as a customer?
Say it again?
How we will come to know as a customer whether they have an agreement or not?
You don't have to. That's the idea with the legislation, is the purpose of the legislation that if DoorDash didn't have a relationship, and DoorDash put it on their web page, or put it so that you thought you were buying from them,
Okay.
and they didn't tell you that, oh, by the way, we don't have a contract with them,
Okay.
okay, then that restaurant
Uh-huh.
would then be able to pursue.
But as a customer, how I'm getting protected out of it?
You as a customer are protected only to the extent that when you placed that order, as far as you knew, the order was coming from this restaurant.
Yeah.
And that DoorDash was facilitating that delivery. So then what we have happen was it got there too late. It was cold. It was not the order you made. It was any one of those number of things. You would often not call DoorDash back.
That is correct.
You would call the restaurant
Restaurant.
back. And the restaurant says we did not know that it was you. All we know that Joe Schmidt called us up and placed the order. In other words, the DoorDash, well, let's not use DoorDash anymore. The XYZ company who took your order doesn't tell the restaurant that they are a delivery company they, as far as the restaurant knows, that the person who's calling and making the order is the person, is not you, is the person. And what was happening was you, the customer, call up and they go, we don't know you from Adam. You know, you can say that was your order. You can say you the order number, but in our case, the order number was somebody else who
Middleman over there.
evidently gave the wrong order.
Okay, but
So that what we're trying to do is protect, this bill is to protect the restaurant owner. Okay, let's call it what it is. This is a restaurant owner protection bill that they're going to pick and choose who can be the pickup and delivery for that restaurant. That not just anybody, Joe Schmo off the street, can claim that they have I can take care of this for you. I remember in the old days, people would call a taxi company and say, will you go to XYZ and pick up an order for me? Okay. But in that case, I'm sorry. But in this case, what we're talking about is that literally, and back in this is the old days, and I would say this problem has been solved because of this legislation, even though it's not in effect right now. But literally in the old days, they would take an old menu from a restaurant, put it on their webpage, and then you would call and order off of that menu. And then when they called the restaurant and they go, well, we don't serve that anymore. We don't have that item. They didn't care. They just filled it in with something else, delivered it to the customer, thinking the customer's going to be happy. And you would then be upset with the restaurant for the wrong reason. It was the company who you called to make the delivery. Did I get that right?
That's right.
okay, so for me right now, the delivery company is the person I need to deal with if my order is bad.
If your order is bad, if you call from the company that is registered with them, yes, you would call them, or you could call the restaurant and say, how did you screw this order up? I specifically said to this guy, and they might say, that's not what he said to us.
Okay, as a customer, my life is miserable out of this thing. Restaurant life is easy because now they are basically getting protected. Your order got messed up. Please deal with that delivery person.
No, they would probably say to you, we'll take care of you. But they would be happy to know that you called them directly and they'll take care of you, because you know why they'll take care of you? Because they're going to go after the person they had a contract with. That's what this bill is all about. They're going to go after that guy who they had a contract with and say, you screwed up one of my customers.
Okay, so they will take care of me. We are just assuming it. There is nothing in the law which protect me as a customer. We will just say that restaurant owner is a good guy or a good person. They will take care of me.
Okay, well, I'll let the person who represents this bill. I would say is at the end of the day is that if you want consumer protection, who do you think should be the one who's at fault for screwing up the order?
Yeah, that is what it is.
Two quick points, but I guess to answer that question, right now, there's no protections for you as a customer anyway, right? It's really at the discretion of the restaurant of how they're going to help you and take care of you. But I think the most important point I would make about this is because the delivery companies would be required to have an agreement in place, the part of that agreement for most restaurants is you have to tell us when you make an order on behalf of a customer. So, for example, you place an order with XYZ Delivery Company. We require XYZ Delivery Company to identify that this is an order that they have received. So now we know that, okay, so we need to make sure that this is done right. We need to make sure it gets picked up on time, it gets delivered on time, et cetera. And if there is a complaint from you as a customer to the restaurant, we know who is involved in that transaction. We can track it down. We can do some research. We can rectify the situation. We can take care of you because we know you're a customer. Right now, if you call XYZ Delivery Company and place an order, we may not ever find out that you placed an order with us because they made the order with the restaurant. We have no idea.
But right now also, you won't find out until I have a problem.
Correct. That's right. Whereas under these agreements, we know, because we know that it came from XYZ, they have to identify that they are placing the order on behalf of a customer, and we're like, okay, that makes sense. Now we know how to react if there's a problem and those kinds of things. Yeah.
Yeah, so I would say in terms of your answer, what protects the consumer is this legislation, because without it, then there is no accountability to the restaurant. The restaurant is saying is, I hear you that you ordered from me, but just so you know, I have no control over this other company that came and did the pickup and delivery, because that's the only name I've got.
Yeah.
So at least with this legislation, and I guess I was missing that point, which is that the restaurant is going to make damn sure they know who the real customer is, not
Yeah, when
the
we
delivery.
complain, we identify ourselves.
where
that-
right,
the
and they'll
restaurant.
know who you are because they can match that up with the order.
Right.
But under what was happening prior to that is they didn't know you from Adam.
I mean, we couldn't even verify if you were a customer because we had no idea.
So right now, each and every customer, as a customer, when we order to the delivery company, as a restaurant, you get that kind of a record right now after this bill, or?
After this bill, we will, because those agreements will have to be back in place, and we will have those discussions, and we will set a delivery price rate. We will make sure that there's a notification that's with every order that it's from XYZ delivery company. There's a whole bunch of, we are also giving the third-party delivery companies, rights to use our brand and our menus and those kinds of, so there's a lot of contractual stuff that goes back and forth in these agreements, but those agreements allows us, because of that communication requirement from both sides, we now know that when you call the company and they place an order with us, we know who you are as the customer. So when you call us with a complaint, we say, so sorry, Mr. Salvi, we messed up your order. How can we make this right for you? So now we know you are a customer. Currently, without these agreements in place, we don't even know if you're a customer. We don't know who you are. We have no record of you ordering any food from us. We have nothing to work with.
And yet, we still
And we appreciate that very much. Yes.
Okay.
All right.
You
that's
feel
fine.
better about it?
I'm okay. I'm not satisfied, but that's fine.
Okay. Yes,
To
Representative
that
Brett.
point, Representative Salvi, I mean, if you go to a restaurant and you sit down at the table and they screw up your order, it's the same thing. I mean, what's your recourse? You say, this isn't what I ordered, or, please make this good. And if it doesn't, you can say, I'm not going to pay the bill, or you write a lousy review. You don't go to the police or, to the Consumer Bureau. That's how you deal with it. And I don't think this is any different.
I think I differ with you, because when I call the delivery person, I basically talk to the delivery person, not to the restaurant, because that is where I paid the money. If my order is messed up, the delivery person is responsible for that, not the restaurant.
Yes, but most consumers don't understand that. So they call a delivery company, they're upset about the order, they call the restaurant. The restaurant has no idea that they even had an interaction with you or served you food or have any idea what you're talking about. So this way, at least everybody knows who the customer is. When the customer calls, we know there's a problem. There's usually some sort of a part of the agreement where we can, share responsibility with the delivery company. So there's just a variety of things that go into this. So, but it's much better for the customer, and it's much better for the restaurants, for both of us in that transaction, because now we all know who each other is, and we can try to do something to make it right for you.
All right. You mean to say now I can call the restaurant also?
You can call whoever you want to call.
And frankly, most consumers are calling the restaurant anyway. They're not calling the delivery company.
Can I make a motion?
You can call both. We already have a motion on the floor. We're in
OTP.
discussion mode. Representative Ammon.
Yeah, I was just going to say, and you touched on it, that the convincing argument to me is that the restaurant has intellectual property, it has a brand, it has an image that it needs to maintain, and if anybody can sort of glom onto that image, that undermines their control over their own brand. So to me, that's a compelling argument.
Right. And someone would blame, the guy who was delivering it was the one who screwed up, but you're going to blame the restaurant because they had stolen their logo and put it on their webpage.
Plus, with this agreement in place, if it's habitual, the restaurant can terminate the agreement with the delivery company
Right.
and have a little bit more control like that.
Correct,
it's a
because
win.
we can then say, look, we've
There's
had
accountability.
multiple complaints in a week, either you need to get a new driver that works on our account, or we need to find another delivery company. So there are
Right.
relief mechanisms that could be pursued, yes,
And creating that communication is a good thing.
exactly.
Okay, did you, Representative McAleer, you have? Okay, Representative Patusa, second by Representative moves, or Representative McAleer. McAleer moves ought to pass. Any more discussion on the motion? Seeing none, all those in favor, seeing none, all those in favor say aye. All right, how many people we got?
Because we're missing.
We're missing Present, okay.
Seven.
All right. Okay, we're done for the day. No, this is just subcommittee. We're not execing yet.
I don't just, and again, the Americans don't already show, but it was really happening. It really was happening. Yeah. I love that show. You ever watch it? The Americans. Oh, it's a really good show. It's about Russia, and they are trained to live in America to get these vibes. It's really good. It's like bingeable. Oh, okay. The Americans, yeah. So you don't have to find it. Sometimes you get. I bet it was. I'm sure you could get it. If you just go on Google and say where to stream, whatever, and I'll tell you. Yeah. But you have to pay for this.
We're done, right? We're done for this.